Hi guys. So um we have all the filings they fell last night. I suppose one of the benefits of being on a different time zone, i.e. being asleep when all of these things are hitting the docket, is I get to wake up with the sound of birds, etc., etc. But the downside is I also wake up to 13 emails with multiple filing alerts. Each filing has, several pages, somewhere, between, less than 10 to more than 100. And so at the moment, I've been kind of wading through, very cursory skimming. So I haven't looked in any great detail. I have seen mention and references to a cookie recipe, which sounds bizarre, but I'll get there. But one thing that really stood out to me was Blake Lively's omnibus memorandum of law in support of her motions in limine. So Blake Lively has filed for 8 motions in limine. And that's okay, that's reasonable. It's what she's requesting, I think, is completely unreasonable. So let's go through that. It's a 32-page document, so this video is going to be a little while. But I'll get through this as quick as possible. But I am doing a full read through, as I always do. And then I'll do a bit of explaining things or, provide my thoughts as and when needed. And I have thoughts on this. You'll have thoughts on this. And I can't wait to read them in the comments. Okay. Oh. Yes. Oh, I hate this laptop. Right. Okay. There we go. Let's begin. Pursuant to the court's case management plan and scheduling order as amended on March 26, 2026, Plaintiff Blake Lively respectfully submits his omnibus memorandum of law in support of her motions in limine to preclude defendants Wayfarer Studios, the Enzo's Movie, and Tag from introducing evidence or making arguments at trial relating to each of the following matters. So I probably should have started by saying, right, motions in limine, they specifically are what is allowed and what is not allowed, right? And in this case, what she wants to keep out. So, like, in the Depp Heard trial in Virginia, all references to the UK trial was precluded as part of a motion in limine. So was Amber Heard's prior arrest for domestic violence. And any mention of who was funding her legal fees. They were all motions in limine. And that is basically where the parties say, hey, we don't want this subject coming up. We don't want evidence of it being presented, and we do not want any testimony or arguments made, in respect of it. So the first argument, which is, this is quite nuts. She wants to preclude improper character evidence and lay opinion concerning her reputation. Now, what does that mean? That means pretty much everything. That's anything that any content creator has ever said in an X post or, any videos on YouTube. That's opinion. We're talking about the real, like, obviously Wayfarer are saying, well, this is organic. The people are just generally pissed off with her because of the marketing. Now she's saying, don't submit that. We don't want to talk about it. We don't want evidence of it. This could also include things such as the location share video, the Forbes video where she talks about, joining as an actress and then pulling the rug and, basically taking over the movie she's on, and how she needs that for authorship, blah, blah, blah. It could also be, what else could it be? Well, it could be pretty much, anything really. just about anything that shows her past behavior. And I'm I'm astonished by this. I'm not surprised by the ask. I'll be pissed off if it's granted. Put it that way. But this is basically taking away Wayfarer's entire defense against, in support of their argument that actually the quote unquote retaliation, what she perceived to be retaliation, was actually people just organically thinking she's a dick. Okay, so let's go. Throughout this case, defendants have insisted, both in and out of court, that the reputational harm Miss Lively suffered was not caused by anything the defendants did, but instead by an organic backlash. So she concedes that's what it is herself. To Miss Lively's own statements that relied substantially on unflattering conduct by Miss Lively from years past. Yet when pressed to substantiate this theory in discovery requests, defendants produced no documents, identified no witnesses with personal knowledge, and offered no competent expert analysis establishing either causation or pre-existing reputational injury. Now defendants hope to smuggle into evidence a combination of gossip, rumour, hearsay, and speculative lay opinion in lieu of admissible evidence. Their objective is to attack Miss Lively with impermissible character evidence, while misleading the jury into believing that their curated laundry list of old events must have played some role in the overwhelmingly negative shift in public sentiment against Miss Lively in August of 2024. The federal rules of evidence do not permit this end run around discovery or admissibility standards. Hearsay, character assassination, and speculation, whether offered by witnesses, experts, or counsel, are inadmissible and prejudicial. For the reasons set forth below, evidence and argument concerning the truth of these gossip articles and any lay or expert opinion speculating about what effect these articles may have had on Miss Lively's reputation or the public's perception of her must be excluded. Background. Throughout this litigation, Miss Lively attempted to directly test defendants' organic backlash theory through federal discovery rules. She served document requests and interrogatories specifically focused on this theory. Not a single document was produced. She served interrogatories directly addressing this theory. No substantive information was provided. Instead, defendants offered a vague narrative asserting in a wholly conclusory fashion that unspecified rumours of discord, marketing decisions, and promotional choices organically created negative public sentiment and prompted unnamed media and internet users to dig up and recirculate unflattering content concerning Lively's behaviour from years past. That response cited no evidentiary support, and to date no competent evidence supporting the defendant's theory has been produced. Defendant's damages expert, Michael Wagner, parrots this organic backlash theory in his expert report. As support, Wagner simply listed examples of allegedly unrelated negative press concerning Miss Lively from January 2023 through early August. Can I just say, I find this so hypocritical given how many times has Lively used Justin Baldoni's TED Talks podcast book as evidence, that, he's admitted that, to not always asking for consent, etc., etc. How many times has she thrown that into filings? And now she's saying, yeah, but you can't do that to me. It's hearsay. It's unsubstantiated. It proves nothing, and it's going to prejudice me. At his deposition, however, Wagner acknowledged that he did not actually perform any actual analysis to determine whether this unrelated negative press was rediscovered organically in August 2024. He admitted that aside from reviewing the complaint and collecting examples of negative press from public articles, he did nothing else to reach his conclusions. He did not apply any methodology and did not attempt to quantify damages. His opinion was purely an assumption. Despite no supporting evidence, defendants appear intent on exposing the jury to a laundry list of negative media studies about Miss Lively, despite having any competent evidence linking these stories to the events in this case. Defendants' exhibit list includes numerous documents that were not produced in discovery that traffic in the same unsubstantiated rumours, gossip, and character attacks. For the reasons that follow, evidence and arguments relating to the truth of these articles or their speculative relationship to the so-called organic backlash should be precluded. Okay. I'm not going to read the unless I see something that catches my eye in the footnotes. I'm not going to bother reading them. Defendants cannot offer the gossip articles for the truth. Miss Lively anticipates that defendants will seek to introduce the gossip articles and other prior unrelated statements for the truth of the matters asserted. That is, defendants will attempt to present argument, elicit testimony, and introduce evidence that relies upon the underlying facts in certain press articles to prove that Miss Lively was, among other things, a mean girl or a bully. Using these articles and stories in this manner, i.e. for the truth, is textbook inadmissible hearsay and improper character evidence. I mean, technically, she makes a point, but also these online articles, the public's perception of her, especially where it's in relation to the marketing of the film. If someone's done, like, say, a TikTok around the time of the marketing of the film and gone, oh my God, what was she thinking? Why is she marketing alcohol, for a movie that's about DV? I think that it should be fair game, because the whole, we are literally balancing Wayfarer smeared me online versus, the public just did not like her because of her own actions. And you've got to be able to introduce the evidence. I mean, also, she's got the burden to prove as well that even if Wayfarer were boosting Baldoni in defense and, kind of boosting negative things about Lively, she's got to prove that it was actually, related to the fact that she made complaints about sexual harassment. She's got to show that causal link. How is she going to do that? At the moment, we haven't seen any evidence of that. We've seen her speculate. People don't like me, so therefore it's all Wayfarer's fault. I'm going to get on my soapbox, so I can feel it rumbling already. By way of brief background, there have been countless tabloid articles and internet stories published about Miss Lively that concern events and controversies that are unrelated to the claims or defences in this case. Miss Lively does not dispute the existence of these articles, nor the fact that certain old allegations conveniently resurfaced in August 2024 and were subsequently amplified as part of defendants' retaliatory campaign. For that purpose, i.e. evidence relating to the existence in conjunction with the amplification of these past articles, Miss Lively takes no issue. However, Miss Lively anticipates defendants intend to go further in their use of these articles and to present argument and elicit testimony as to the truth of the underlying facts contained in these articles. Used for this purpose, it is inadmissible hearsay and should be excluded. Even if defendants proffer a permissible basis for using published articles that fits within Rule 803, preclusion is separately warranted to the extent that defendants intend to use these articles for the purpose of creating a negative impression of Miss Lively, so that the jury will draw adverse conclusions about her character. Circumstantial evidence offered to show that Miss Lively is the type of person who provokes hostility or deserved backlash is precisely the form of evidence that Rule 404 forbids. Right, so there it is. Your Honour, their evidence is going to make me look bad, so let's just keep it out. This is such an Amber Heard move. In sum, any effort to rely upon unrelated controversies to argue that Miss Lively is the kind of person who deserved an organic backlash, or in defendant's words, a bully, should be precluded under Rule 404A1 as improper character evidence designed to improperly invite prejudicial propensity reasoning. Okay, so translated loosely, she doesn't want anything that makes her look bad. I'm sure she doesn't want any of the videos where her husband sits in interviews and admits that he stares at a woman breastfeeding in a hotel, or, you know, grabbed Olivia Wilde's naked breasts after the director had yelled cut. I'm sure this will all make, you know, it might damage her case a little if that comes out. I mean, it's out, but she's like, yeah, but I don't want the jury to see it. Defendants cannot offer inadmissible lay opinion as to Miss Lively's reputation. Miss Lively separately anticipates that defendants intend to rely upon the gossip articles and others like them for the purposes of establishing that Miss Lively carried a negative reputation and public perception prior to August 2024. So this is a, please don't bring out the backlash to me being cast because I'm too old for the role. I'm speculating. It doesn't say that, but like, you know, and if she's saying anything before August 2024 is not fair game, I want to keep that out, then that's effectively what she's saying is, you know, because there was a huge backlash to her even being cast. So, defendants were free to develop and establish this theory during fact and expert discovery. They failed to do so. No evidence was produced in discovery to support this theory. Instead, defendants referred generally to the existence of negative articles and internet posts. Because this theory rests on improper lay opinion, it's inadmissible under Rule 701. To begin, defendants failed to retain an expert to analyse and determine whether the prior gossip articles in any way impacted Miss Lively's reputation prior to August 2024. The opinions of Mr. Wagner and Ms. Alexander, which are the subject of Daubert motions, do nothing of the sort. They conducted no causal analysis, applied no methodology, and merely catalogued negative press, while Mr. Wagner conceded that his conclusions rest on assumptions. I mean, her expert wasn't very good either. I'm just going to put that out there. I didn't like Nicole Alexander's I didn't like her deposition. Her report may be better, but to be honest, it's important to judge the deposition as well, because, you know, we're talking about how she's going to present at trial. And if she struggled at a deposition, she is going to really struggle at trial. And how an expert presents their evidence and their knowledge is kind of important, actually. If we go again using Depp Heard, because it was a televised, I use it a lot because it's obviously a televised American case, which is built on similar themes, and, you know, has the same kind of important PR, you know, the role of PR and everything in it. So it's as close as I can get to a like for like, and because it was televised, so we all saw it, and if we haven't, we are able to see it through the various YouTube videos. But when you look at Lively's DV expert, oh god, I can't even remember her name. Dawn Hughes. I want to say Dawn Hughes. If you look at Lively's DV expert, Dawn Hughes, or Dr. Spiegel, oh my god, Dr. Spiegel, and then you contrast how they came across on the stand with Dr. Shannon Curry. That went a long way to Depp winning the trial. It's when I started law school, when I went to university and started my law course, in the first week, actually, in the introductory sessions, we would basically walk through what it takes to win at trial. 50% is the evidence and the law being on your side, but the other 50% is the moot. And when we say moot, like it's not in the same context as, I'm denying this because, it's a moot point. The moot is what is what the legal argument is referred to. So when a lawyer is at trial presenting their argument, they're mooted. And it's the way you present the argument, how persuasive you are, the etiquette you use. That is half of your battle. And if you can have that is why people who have what on the surface looks like really weak cases can still go on and win, because they are persuasive enough in the way they deliver, the way they present their arguments, their evidence. So and the same goes for experts. It's one thing to have a witness who was like, maybe, like a member of cast in this situation, or a member of Johnny Depp's staff, who's not, used to routinely like sitting in a court and giving evidence. And you can see they're nervous, they're just doing their best, etc., etc. And that's a very different way you look at them very differently than you would at an expert witness, because they're supposed to know what they're talking about. They're supposed to be clear, concise, succinct. They're supposed to demonstrate their knowledge and how they applied to the facts of the case. And they're supposed to deliver that, with an element of persuasion in and of itself. So, because that's what you're going to get two competing experts, right? They will each have, in this case, an expert on DV. And basically one expert has to say, here, to the jury, they have to say, this is why you should listen to me. This is why I'm right and they're wrong, and vice versa. And then they have to effectively, there's an element of mooting between them. There's an element of having to persuade the jury. I'm going to get back to this, though, because I went off on a big tangent. I said I was going to get on a soapbox. But it is important to kind of say, that I don't... yeah, I mean, it is important, the expert analysis. And, I don't think... I know people have said, well, yeah, deposition didn't go well, but what if her report is great? That's great. But the jury are not going to be overly reliant on the report. They're going to be relying on her talking about what is in her report. So the deposition, for me, was an indicator that she could be problematic at trial. And that's putting it gently. We continue. Collecting negative press is not the stuff of experts, and in any event fails to support defendant's theory that Miss Lively carried a negative reputation prior to August 2024. What remains is general lay opinion as to what witnesses believed of Miss Lively's reputation. It is well settled, however, that a layperson may not offer opinion testimony on public perception or reputation. Here, defendants have failed to identify any witness with first-hand knowledge that Miss Lively had a negative reputation prior to August 2024. Any such testimony or argument should be precluded. The gossip articles and prior statements should be excluded under Rule 403. Finally, even if defendants could articulate marginal relevance, and there is none, the gossip articles and other prior unrelated statements should nevertheless be excluded under Rule 403, since any probative value is substantially outweighed by the risk of unfair prejudice, confusion of the issues, or waste of time. Among the hit list of articles defendants hope to send back to the jury room: 1. A 3-paragraph article from 2009, in at which Miss Lively is reported to have used the word tranny. Oh. 2. An article from 2020 referencing an alleged 2012 plantation wedding in the hopes of suggesting racism. Girl, you were fucking racist. Wow, you were racist. And it's not an alleged 2012 plantation wedding. You got married in 2012 on a fucking plantation. Oh. And 3, A 2014 article entitled Blake Lively Wants to Return to a Time of Cute Hats and Slavery. Yeah. Oh, this is entertaining. And defendants hope to introduce this evidence without any expert testimony that these articles or others like them had any impact on the public sentiment regarding Miss Lively at any time, let alone during the only relevant time just before and then following August 2024. I mean, yeah, okay. It's hard for them kind of documents that evidence to show that's why everyone backlashed against her for the film. I understand her point there. But she's also dropped in that, that they don't show that there was any impact on public sentiment regarding her at any time. No, that's not true. She had substantial backlash for each of those things, and they ended up making a donation to I can't remember the name of it, the charity for, black minorities. NAACP. I don't know. I can't remember the exact acronym, so apologies, but oh. Wow, Blake Lively's trying to say she's not racist. The thing is, right, people are going to say, well, why is that relevant? Well, and I don't entirely subscribe to a race card being played in this case because Wayfarer have not alleged racism. Obviously, Jamie Heath is a black man. And that's as far as I go, right? So they may want to say, well, there may have been racism towards Jamie Heath, which is a fair argument to make. They have to prove it, though. They have to prove that there was like a racial intent there. You can't just say it, and because he's black, it will stick. That's not how that is going to work. But I agree that the argument could be made. However, although Jamie Heath is a black man, we need to remember the other men that were brought into it who were not black. That would be Justin Baldoni, Steve Sauerwitz, and Jed Wallace. Right? And also all the attacks on freedmen. None of those men are black. So for that reason, whilst I understand people's outrage and they do bring up her very obvious past racial behaviour and try to link it to Jamie Heath, and I'm not saying it's not there either, but there were, there were more white men. There were also white men brought into this as well, and more of them. So I don't know that there was a racial element, but the most important thing is Wayfarer have not actually made that allegation themselves. So if they're not making the allegation, at least in their complaint and counter complaint, they have not made that allegation. Then I don't know that that's what the intended purpose is. I mean, because also there was, there wasn't all about race there. There was also the tranny comment. It might just be to show that she is a nasty bitch, which is absolutely fair. Absent such testimony, these articles do not satisfy the relevance threshold of Rule 401, and any relevance that should be would be substantially outweighed by the obvious danger of unfair prejudice caused by placing this selection of very negative articles before the jury. At least she concedes that they are very negative, which in turn that seems to agree that her behavior was very negative. Okay, motion in limine 2. Sorry, I'm still tired. This one's wild. She wants to preclude evidence and she wants to preclude evidence and argument relating to the Vanzan subpoena and Vanzan action. What? This I can't believe. So she wants to keep out any mention of her sham subpoena that kick-started all of this in the first place. Okay. Where a lot of her evidence that she's going to rely on came from. She's now about to argue about why this is the Vanzan, the subpoena, the action is not relevant at all. You're going to like this. I did read this in a bit more depth. Throughout this case, defendants have raised arguments concerning a subpoena issued by Vanzan Inc., a non-party entity that, at the time, right, you're going to like this, at the time was pursuing litigation in New York State Supreme Court against those defendants. The Vanzan subpoena has never had any bearing on any element of Miss Lively's claims. Are you fucking joking? I agree, it didn't have any bearing on her claims. But that is... that's wordplay here now, right? Because it clearly did. She filed that whole lawsuit and got the subpoena to get the evidence from Jones' work. She didn't send out any other subpoenas. And, you know, I'm not going to go over the whole thing because we know this. We've got this rehearsed now down to a T. Obviously, none of those defendants had anything to do with Jones' work or Jen Abel's phone, but yet that was the evidence that was requested and produced. And now she's sitting there going, well, they're separate. They had nothing to do with each other. I can't wait to see the Wayfarer's response to this, right? Because what I said, right, from the start was, when it comes to motions in limine and the whole Vanzan of it, I thought Wayfarer had specifically two obvious options. One was they could file their own motion in limine and say, hey, we want everything that was, you know, all the ill-gotten gains from Vanzan, we want that kept out because of, you know, it was unscrupulous, it was immoral, it was unethical, and it, you know, it should never have happened. So therefore, she should never have had the messages. And then that would have killed her retaliation claim, in all fairness, because then she would have struggled. But I do have an issue here with this, right? The other possibility they have then is that Wayfarer were just going to let it go, right? Let Vanzan, all the text messages stay in, and take the opportunity to, you know, talk about Vanzan, how these text messages were obtained, and, you know, what a deceitful, manipulative bitch Blake Lively, her legal team are. And I know I will do Wayfarer's motion in limine as the next video, but I already know that they did not file a motion in limine to keep out anything that was obtained through the Vanzan subpoena. So it sounds like, you know, we now have our answer. They were going with the second option where they were going to say, hey, you know, yeah, okay, there's all these text messages, but they're out of context. They're manipulated. Oh, by the way, did you hear about how she got them in the first place? That was also manipulative. And Lively is trying to say, no, nothing to see here, but let's just not talk about it, you know, because it's not relevant. How I got it is not relevant. Okay, so that line in itself, the Vanzan subpoena, has never had any bearing on any element of Miss Lively's claims. I just think that's ridiculous because she has to say how she got the text messages. It's actually in her complaint. She says she obtained them through a subpoena. So I don't think it's unreasonable. I would hope Judge Limine says, no, you're not having this, because it's not unreasonable then for Wayfarer to say, well, hold on a minute, you raised this topic of the fact that you got these through a subpoena. Let's talk about that subpoena. And they do bear the relevance in terms of retaliation. Defendants have relied on it not because it makes any fact of consequence more or less probable, but because it has served as a convenient vehicle to argue in the press that Miss Lively or her counsel engaged in some form of litigation misconduct that has never been put before any court. Now, I do agree that it has not been put really through the court, like in a formal way. It has been put informally, but I'm sure Wayfarer had a plan or have a plan with that, and that still may be coming. But again, the wordplay here. And don't forget, this document is also going to be part PR, as with everything else she does. The authenticity and relevance of the materials produced in response to the Vanzan subpoena is not in dispute. No, that's not quite true. Wayfarer made it very clear that you spliced and diced it. Those were their exact words, actually. And they gave examples of, you know, Lively's exhibits and then their own, what the actual thread really looked like when you put back in the messages that were taken out. So, in terms of authenticity, though, generally, like, did this stuff come from Jen Abel's phone? Yeah, that's not in dispute. The only conceivable reason for defendant's suggestion of impropriety is to cast an unfounded cloud of suspicion that the documents produced are unreliable because Miss Lively or her counsel purportedly did something improper. Wow. But that is just a wild thing for her to be putting in here. That's just fucking crazy. But neither the Vanzan subpoena nor the underlying Vanzan action have any bearing on the claims to be decided in this case and would create substantial risk of prejudice, jury confusion, and needless consumption of trial time. For these reasons, such evidence should be excluded. Background. Let's look at the background. Miss Lively is the president and a 50% owner of Vanzan Inc. Vanzan was established after Miss Lively and Ryan Reynolds were married in 2019. 2019? Oh, it was established in 2019. They married in 2012 because we just established that through the plantation wedding. Vanzan were established after they were married in 2019 to handle payroll and other administrative matters for a variety of household employees. On September 27, 2024, Vanzan commenced the Vanzan action. In connection with that action, Vanzan served the Vanzan subpoena on Jones Works. Okay, so do any of the household employees work for Jones Works? Are they connected to Jones Works? Jones Works produced materials in response to the Vanzan subpoena. No motion to quash or other legal challenge to the Vanzan subpoena was ever filed by defendants or anyone else. No, of course not, because the defendants were never fucking told. That was the whole point of doing the subpoena that way, was so that they never got notice to exercise their right to object. Oh my God, I'm so pissed off with this woman. I really am. This is like, when I did my video the other day, I think it was the part 2, and I talked through some parts of my motion to quash, and I specifically brought up a letter, Ezra Hudson, where she was talking about, in relation to these non-parties, i.e. the 5 people, us, myself, Kjersti, Lauren, Ken's, Ashley, who had filed motion to quash, right? And she specifically said in relation to these people, and then she went on to talk about how there was meet and confers and all that, which did not exist with us, but they may have existed with other subpoenaed non-parties, who didn't file motions to quash. But the use of the word, it made it sound like we had meet and confers, and not only that, but she needed no further information. It suggested that we gave information, and this is the same sleight of hand that she's playing here with the words, and it is pissing me off so much. This is just anger inducing now. And no court has ever ruled that the subpoena or Vanzan action was improper in any way. Well, hopefully Judge Limine will do that. Vanzan voluntarily dismissed the Vanzan action on December 19th, 2024. Defendants have characterized the Vanzan action as frivolous and sham, and they have made general baseless accusations that Ms. Lively conspired to misuse legal process. Bitch, you did. They have echoed those accusations publicly in the media, and have forced the Vanzan action into filings in this case, notwithstanding any actual or articulated relevance to Miss Lively's claims or their defences, despite their counsel's public threat nearly a year ago to take all action allowable under the law to address this supposed abusive process, defendants have never challenged the validity of the Vanzan action or Vanzan subpoena, likely because they have never found any action allowable under the law that would make such a challenge cognizable. No, because I can't speculate why Friedman hasn't done anything about it. I'm sure there are reasons. I trust Friedman. Yeah, I suppose it is a bit annoying that he hasn't done anything. That someone hasn't done something about it. Argument. The Vanzan action and Vanzan subpoena are irrelevant. Evidence or argument. I'm getting annoyed now, so I can hardly get my words out. Evidence or argument concerning the Vanzan action and Vanzan subpoena does not make any fact of consequence in this case more or less probable, and is therefore irrelevant under Rules 401 and 402. This case concerns Miss Lively's claims for retaliation based upon engaging in protected activities relating to sexual harassment that she experienced and observed on the set of the film. The Vanzan action was a separate, unrelated New York State Court contract dispute brought by a non-party entity against unidentified defendants, none of whom were defendants, and shared no overlapping claims, elements, facts, or legal issues with those to be tried here. Well, no, but they shared overlapping evidence that did not seem to make any sense to be relevant to these unidentified does. Evidence concerning collateral litigation of this kind therefore has no tendency to prove or disprove the claims at issue in this case. For these reasons, courts in this district routinely exclude evidence concerning other lawsuits on precisely these grounds, and she's cited some cases there, one of which is Limene's. At no point have defendants asserted a claim or defense in this action that places the propriety of the Vanzan subpoena at issue. And that's true. They haven't really. That has all been taking place on the Jones-Abel docket. So, yeah. They have not sought relief in the issuing court and have not taken any steps in this case to exclude any of the evidence obtained from the Vanzan subpoena on any basis, much less abusive process. Again, and they haven't done that with their motions in limine as well. So they therefore cannot invite the jury to infer wrongdoing that they have chosen not to litigate. At bottom, defendants take issue with the fact that their untraceable plan to bury and destroy Miss Lively was discovered. But that is not a defense. In fact, the very same evidence about which they complain now would have been subject to production in this action. Defendants should not be permitted to cast doubt on relevant evidence by suggesting to the jury, directly or indirectly, that it was improperly obtained. I mean, it was, though. Because I don't think she would have filed the action without that evidence. Because the Vanzan action and Vanzan subpoena lack any cognizable probative value, any such evidence or argument should be excluded under Federal Rules of Evidence 401 and 402. Evidence concerning the Vanzan action and Vanzan subpoena should also be excluded under Rule 403. Even if evidence concerning the Vanzan action had any marginal relevance, the risk of prejudice to Miss Lively and jury confusion and wasted time substantially outweighs any marginal probative value, which separately warrants exclusion under Rule 403. Where a party seeks to introduce evidence of alleged litigation misconduct in other cases, the dangers of unfair prejudice, jury confusion, and waste of time are quite real. For example, as in the example from the ignition switch litigation, despite the absence of evidence that one party engaged in any litigation misconduct, jurors may seek to punish that party for what they view as an overly aggressive litigation strategy. Indeed, defendants are likely counting on such a reaction. In any event, the propriety of how evidence is obtained is a question of law for the court, not a question of fact for the jury. If there was some basis to preclude Miss Lively from using the materials Vanzan obtained in response to the Vanzan subpoena, and if defendants had raised such a challenge, that would have been a question for the court to decide out of the jury's presence, much like a suppression motion in a criminal case. And just as a criminal defendant may not relitigate a suppression motion he did file by attacking the government's conduct in obtaining the evidence, defendants cannot now attempt to litigate a suppression issue they did not raise by casting doubt on the Vanzan subpoena's propriety. Moreover, admitting this evidence would require the court to allow Miss Lively an equal opportunity to challenge and rebut those accusations, requiring evidence and arguments surrounding the details of New York civil procedure, generating a mini-trial within the larger trial, and a sideshow at that, given that the origins of the Vanzan subpoena are hardly central to the issues in this case. That detour would unnecessarily consume the jury's time and risk confusing the issues before them. Well, I say, don't worry about the jury's time, because we've just saved a lot of time by getting rid of 10 causes of action. So, we have some time now. Motion in limine number 3. Preclude evidence concerning the character Nicepool in the film Deadpool and Wolverine. Your Honour, let's not tell the jury how me and my husband bullied Justin Baldoni on a global stage. The court should exclude any evidence or argument regarding or making any explicit or implicit reference to the character of Nicepool in the film Deadpool and Wolverine, because the court has already determined such information is irrelevant. No, I'm going to correct that. That's not true. What the court did was said it was not relevant to the claim of defamation. Wayfarer's claim of defamation against Ryan Reynolds, right? It was quite specific because it's free speech, okay? And satire is protected. So they couldn't rely on the claim. Limine did not say that the character was entirely irrelevant to the entire, lawsuit. It was just that, the claim could not pass. Wayfarer's claim relating to the creation of Nicepool could not pass because it was, First Amendment kicked in. On April 8th, 2026, defendant added Nicepool clips from Deadpool and Wolverine as exhibits extensively as part of an intent to perpetuate the same character assassination of Lively as a mean girl and bully, and to paint Baldoni as the victim. What's the victim, for fuck's sake? Because this court has already determined that evidence relating to the Nicepool character is not relevant, defendants are foreclosed from now introducing any such evidence under the law of the case doctrine. By way of background, in their now dismissed and sanctioned lawsuit against Miss Lively and her husband Ryan Reynolds, Wayfarer and the Enter This Movie claimed that the character of Nicepool was a transparent and mocking portrayal of Reynolds' warped perception of Baldoni, and a vicious caricature of Baldoni that provided evidence of mocking and bullying. In its order dismissing their lawsuit, the court held that these Nicepool allegations, i.e. those relating to the alleged portrayal as Baldoni as a fake feminist who makes inappropriate comments, do not support the claim that Reynolds disliked Baldoni for reasons independent of his belief that Baldoni engaged in misconduct, as opposed to for that very reason. The court also addressed the irrelevance of Nicepool in another order entered the same day that The court also addressed the irrelevance of Nicepool in another order entered that same day. Non-party Marvel Entertainment's motion to quash defendant's subpoena that sought inter alia all documents relating to Nicepool. I mean, she's taken that out of context. In that order, he said, and bear in mind, we're talking about, the relevance of Nicepool in terms of obtaining discovery from Marvel. That is not the same thing, right? So in that, he did say, dismissing Wayfarer Party's claims, the information sought is no longer relevant to a claim or defense in this action. So what he meant by that was discovery is not needed. But that's not the same as, saying, hey, you can't introduce clips, publicly available clips. And it's, I just, the words here. Having already found that information relating to Nicepool is no longer relevant to a claim or defense in his action. Yeah, from Marvel. That'd be the work product, where did the inspiration come from this character? How was he developed over time? At what point were certain things like, about monetizing the women's movement, etc. What point were they written into the script? What, all the various script changes. This isn't. This is not the same as showing, clips of the film and the outtakes. The court should not permit the introduction of any related evidence during trial. Even if arguendo there were any marginal relevance to Nicepool, Rule 403 prohibits its introduction because of the likelihood of prejudice and confusion. Indeed, it would be manifestly unfair to permit the defendants to use the Nicepool video to imply or advance any argument because it would be predicated on an undeveloped record by virtue of the lack of any discovery on the topic. Motion in limine 4. Preclude testimony and evidence regarding Miss Lively and non-party Ryan Reynolds' net worth and financial status. This is one thing I suppose I do agree with her on. It's not relevant because she's not going to have to pay any damages to Wayfarer regardless of the outcome. So I do actually agree that their wealth and their net worth is just not relevant here. So I do think that information should actually be kept out. But insofar as proving any losses, because she's obviously claiming, well, I lost this and I lost that and I lost that. Now, we don't need to know their net worth for that, but we do need to know what did she lose out. And we do need to see evidence that, a decline. She says she lost money. Her brands lost money. We need to see evidence of that. But in terms of what's in her bank balance, which is ironic because she asked for my bank accounts, it's not necessary. So she's asking for the net worth and financial status to be taken off the table. In a limited capacity, I agree. I do certainly agree with Ryan Reynolds. There's no need to know how much he's worth, and I don't care. But it should only be enough from Lively in terms of proving the losses that she's claiming she's sustained because of claims, because of Wayfarer's actions. Miss Lively and her husband, non-party Ryan Reynolds' net worth and financial status are not an issue and not relevant. In fact, like the Nicepool evidence discussed above, because we have to, conflate issues that have no business being conflated, the law of the case bars defendants from attempting to introduce this evidence. During discovery, this court considered and rejected a similar issue in which defendants sought to compel evidence regarding Miss Lively's net worth over 9 months ago. A party's net worth is only relevant if there is a finding that punitive damages should be awarded. Even when punitive damages are at issue, only the wealth of the defendant, not the plaintiff, is relevant. Here, as the plaintiff, Miss Lively is not subject to any damages, much less punitive damages. It follows evidence of her personal financial condition is not relevant and should be excluded on that basis alone. The same holds true for Mr. Reynolds, who is, as a non-party, the relevance of his net worth is even more attenuated. Because settled law recognizes that a plaintiff's net worth is not relevant, testimony and evidence relating to the same should be precluded at trial. Even if Miss Lively's or Mr. Reynolds' personal wealth were relevant, any marginal probative value of this information would be substantially outweighed by the clear risk of prejudice it may present in influencing or triggering biases against wealthy individuals. Oh. We're playing the wealth card. That's a new one. Wow. Cases are legion on this score. For each of these reasons, evidence of Miss Lively's and Mr. Reynolds' net worth should be excluded. And if they weren't, what that would show is Ryan Reynolds is worth a fucking fortune and she not so much. Motion in limine, number 5. Preclude internal Sony communications. I love this. Internal Sony communications. This would be is it Panich? Sanford Panich, Ange Giannetti, Josh Greenstein. These would include text messages between, I think it was Ange Giannetti and Sanford Panich, where Sanford Panich called Blake Lively a terrorist, or where she detailed how Lively was demanding her own cut and was basically extorting Josh Greenstein to get her own cut. That's what she wants to keep out. Even she don't let them talk about Sony text messages which make me look like an asshole and back up all their claims. That's what this is. So, based on their exhibit list, defendants intend to introduce and reference internal text message communications from non-parties Sony, several of which are incomplete, one-sided messages. Well, shit. Where else have I seen that? Could that possibly be Jen Abel and Melissa Nathan's text messages were one-sided, incomplete? I'm hoping Wayfarer makes that argument in comparison. Because the authors of these messages lack personal knowledge regarding the subject matter discussed therein and the messages themselves are textbook hearsay, exclusion is warranted. That could all be applied to Melissa Nathan and Jen Abel's text messages that are specifically she's thrown into every complaint and claims is evidence of retaliation. You know, there was messages where Melissa Nathan was, wasn't it? I'm sure it was Melissa Nathan said something about it just goes to show everyone likes to hate women. They were actually talking about Stephanie Jones, and Stephanie Jones claimed that message as, referring to her in her lawsuit. Then Lively also claimed it as referring to her in this lawsuit. But honestly, applying Lively's logic here, what actual knowledge did either of them have? Jen Abel weren't on set. Melissa Nathan didn't even come in until after filming had completed. So any messages that refer to Lively's claims or the validity of them, really, are they also not just textbook hearsay? And, the people speaking are lacking of personal knowledge regarding the subject matter? But, she won't see it like that. By way of brief background, defendants have included a series of internal text messages between and among Sony employees Ange Giannetti, Sanford Panich, and Josh Greenstein. In these messages, Miss Giannetti, Mr. Panich, I think it's Miss Panich, I'm sure she's a woman. She is a woman. I'm sure she's a woman. And Mr. Greenstein discuss, among other things, Miss Lively's protection document, efforts to edit and improve the film, and marketing. Well, yeah, but that's what Melissa Nathan and Jen Abel do too. So should we just exclude their messages for the same reasons? None of the speakers witnessed firsthand the events leading up to the protections document. Again, I repeat my previous statement. For their part, neither Miss Panich, I'm not saying Miss Panich, nor Mr. Greenstein actually ever stepped foot on set. Again, neither did Jen Abel or Melissa Nathan. Putting aside relevance or personal knowledge, exclusion is separately warranted because these messages are textbook hearsay under Rule 801C with no cognizable exception. Preclusion of the incomplete messages is separately warranted because they are missing the entire communication, therefore rendering each message misleading and confusing under Rule 403. Is this woman still fucking tone deaf? How many messages between Jen Abel and Melissa Nathan did she put in, and Wayfarer clearly demonstrated there were missing messages literally in that thread, not, way down. I said I was going to get annoyed. I'm not going to apologize. I've never seen anything so hypocritical and filled with dumb fuckery as this. In a transmittal note from Sony's senior litigation coordinator, Sony acknowledged this very issue, admitting that their production contained image text threads from Mr. Greenstein's phone, which were one-sided. Right? Notwithstanding this deficiency, defendants focused their examination of Mr. Greenstein around many of these very texts. Okay, and then there's some stuff redacted. In response, defendants' counsel conceded that redacted. To date, defendants have not provided an explanation as to where these certain responses are located, nor have they provided insights into the subsequent communications that they have had with Sony, such that they would be able to obtain fulsome text to make the production whole. I'm looking forward to seeing Wayfarer's clap back at this. I really hope they do. I'll be kind of annoyed with Wayfarer's attorneys if they don't at this point, because they are letting this stuff slide to some degree. Right, and whilst I can understand there's probably a plan, and it's all in hand, I do think that there are some things they should push back a bit harder on. Incomplete texts of this nature are highly misleading. Well, yes, I'm glad she realizes that. I was beginning to think she didn't know. And any probative value they have is substantially outweighed by the danger of unfair prejudice and jury confusion. These concerns are illustrated by the deposition of Mr. Greenstein. On several occasions, Mr. Greenstein was asked by defendants to speculate whether he recalled the substance of incomplete text conversations based on a cursory review of the one-sided text threads. Mr. Greenstein responded in many instances that he could not, testifying further that for certain text threads he was unable to identify the particular party he was actually communicating with. These examples demonstrate that the texts in Sony's production present an incomplete picture of the communications Mr. Greenstein had with various parties in connections with the claims of this case, and thus would serve no other purpose than to confuse and mislead the jury, which Rule 403 is intended to prevent. Okay, so where we are at this point now is, let's exclude Vanzan, who was the catalyst for this, and let's exclude Sony, who was kind of in the middle of all of this. And I'm telling you now, that's why everyone's saying, why didn't she sue Sony? Because Sony would have been subject to more extensive discovery. And she doesn't want that. It's the same way, like I said, why did she sue? Why did she initiate the lawsuit in the first place? I don't think she ever intended to initiate the New York lawsuit. So why do I personally, this is just my personal opinion, why do I think she did that? Because Wayfarer chose not to sue her. So she would not have been subjected to discovery except as a non-party, potentially. They sued the New York Times. And if discovery was produced, any of Lively's messages, etc., between her and anyone from the New York Times or anything else, that would have taken the control away from Lively. And I don't think she wanted to do that, because you saw, like, with our motions to quash, one of the arguments she made was, well, we didn't subpoena you directly. We subpoenaed X or Google. Technically, you have no stand-in for this, this, and this, and this. And she wasn't wrong, but she didn't sue us directly because it took away the control from us. And I think that's what happened when that's what made her file the lawsuit, was to have some control. Because if she wasn't a party, as she wasn't in the original California case that Wayfarer brought against the New York Times, she wouldn't have had that control. And if we've not learned anything else, she loves control. I mean, she obviously had to, initiate her own lawsuit because she needed, to feel, what was it, authorship? Okay, motion in limine 6, preclude evidence concerning defendants' alleged post-litigation harm. So this is her, we all remember very recently when the judge issued the order on the motion for summary judgment, dismissed 10 of her claims, including the sexual harassment claims. She went on a crash out on her Instagram. Her lawyers come out making all kinds of statements. Sigrid McCauley completely contradicted her January statement where, it was important to pursue this action for people who have experienced sexual harassment in the workplace, and now sexual harassment in the workplace was out. It's always been about retaliation. And, they obviously don't want the little dragon emoji in there either. Lively is saying, please don't make this a thing. After putting it out there in front of a potential jury pool, she doesn't want to give Wayfarer the opportunity to question any of its contents, any of the discrepancies. This also includes the community note, by the way, which it was gone by the time I saw it. Well, by the time I was alerted to it, it had already been taken down. But I've seen screenshots and it's just epic. But for her post to get community noted was just hilarious. But she also wants to keep that out too. So it's not even her own words, her lawyer's words. It's what the Instagram community thinks of bullshit. Ms. Lively anticipates that defendants will attempt to introduce evidence and elicit testimony concerning how the litigation has personally affected them. Such evidence is irrelevant to any claim or defense, substantially prejudicial, and serves no purpose other than to invite jury sympathy and distract from the merits. It should therefore be excluded pursuant to Rules 401, 402, and 403. It is well settled that the trier of the fact must consider only the factual issue of liability without regard to any potential consequences which may befall a defendant. Accordingly, evidence that a defendant claims to have suffered hardship, threats, or other harm as a result of being sued has no bearing on liability and is inadmissible. Federal courts routinely exclude evidence of litigation-related hardship because it serves only to appeal to jury sympathy and risks verdicts based on emotion rather than law. Here, defendants have repeatedly sought to portray themselves as the victims in this litigation rather than litigants defending the merits of Miss Lively's claim. In their since dismissed amended complaint, Wayfarer and It Ends With Us movie alleged that Miss Lively purportedly attempted to serve Mr. Baldoni and his team during the January 2024 Los Angeles wildfires. You did! Oh my God, you did. You tried to serve, and then you refused Friedman an extension, a reasonable extension to respond to something, even though he just lost his house and his law firm caught fire. I mean, for fuck's sake. Something's redacted. Continuing this victim narrative, something else is redacted, something else is redacted. None of this evidence bears on any claim or defense remaining in the case. Well, it shows what a hideous person you are, right to your core. Wayfarer and It Ends With Us movies claims were dismissed almost a year ago. How they reacted to being sued in no way addresses the issues to be presented at trial. Oh, sorry, these ones are this. So this is not. This is the Wayfarer. These are Wayfarer statements post the dismissal of their complaint. She does actually ask for motion in limine on her own statements as well, so that's coming next. But I misread that. Sorry. None of this evidence bears on any claim or defence remaining in the case. Wayfarer and Ainsworth's claims were dismissed almost a year ago. How they reacted to being sued in no way addresses the issues to be presented at trial, and for that reason warrants exclusion. What is more, permitting defendants to introduce evidence or argument concerning alleged post-litigation harm would improperly present themselves as victims of the lawsuit itself and invite the jury to decide the case on sympathy rather than the evidence, which Rule 403 strictly forbids. For these reasons, evidence concerning defendants' alleged post-litigation harm should be excluded. Okay, motion in limine number 7. This is her statements. Preclude evidence concerning statements by plaintiff and her agents regarding the court summary judgment order on proceedings. The court should exclude any evidence or argument regarding or making reference to statements by Ms. Lively or her agents regarding the court's proceedings or ruling on summary judgment. The motion for summary judgment statement evidence lacks any bearing on this litigation and instead reflects defendants' transparent attempt to make the participation of their counsel in the press into a both sides issue. That attempt is improper, and the motion for summary judgment statement evidence should be excluded as irrelevant and substantially prejudicial to Miss Lively. It's prejudicial to her because she's such a dick. You put an emoji right at the end of a long-winded ramble about how you're a voice for all women. On April 8th, 2026, the defendants added the following to their exhibit list. So this is Lively's statements on Instagram, Gottlieb's statements, Sigrid McCauley's statement as well. This is all about retaliation. It's always been about retaliation. Her January one as well, where it's at the time it was about the sexual harassment. And then the community note regarding Blake Lively's post. Each of the exhibits above consists of statements by Ms. Lively, her attorneys, or her legal spokesperson regarding the parties' oral argument on summary judgment or the court's recent summary judgment decision. First, the motion for summary judgment statement evidence is irrelevant to the claims and defences in this action. Defendants can offer no explanation as to how these statements, which long postdate the close of discovery, bear any relation to any claim or defence in this case. They appear to believe that this evidence is somehow relevant to contrast with the statements made by Mr. Friedman when the defendants launched their retaliatory, frivolous and sanctioned $400 million lawsuit against Ms. Lively, Mr. Reynolds and others. But that is a false comparison, of course it is. That is a false comparison that inverts the actual claims remaining in this case. Ms. Lively is the only party with affirmative claims in this case, and it is her retaliation claims rather than defamation claims that will be tried to the jury. Well, not if the new motion for summary judgment and or motion for judgment on the pleadings have anything to say. So, let's watch this space on that. It could be just a breach of contract claim for all we know. Many of Mr. Friedman's inflammatory statements made in the period starting in December 2024 through February 2025 were published in support of defendants' now dismissed and sanctioned lawsuit, and they are therefore highly relevant to the harms caused by that retaliatory conduct. As this court recognised and has been extensively documented, Mr. Friedman is alleged to have participated directly in the retaliatory campaign against her in other ways. There are no similar allegations regarding Ms. Lively's team, nor could there be any that would even plausibly be relevant, because the defendants have no affirmative claims against Ms. Lively, and the conduct of Ms. Lively's various agents over the past month says nothing about whether the defendant's sanctioned lawsuit constitutes retaliation as a matter of fact or law. Second, even if the motion for summary judgment statement evidence were marginally relevant to the case, it should nevertheless be excluded under Rule 403. Defendant's motion for summary judgment statement evidence will mislead this jury into thinking that the same rules apply to Miss Lively and defendants. They do not. Even putting aside that the motion for summary judgment statement evidence cannot even conceivably be regarded as retaliatory against defendants in any sense, defendants alone were contractually and or statutorily bound to avoid retaliating against Miss Lively. Thus, defendants' attempt to introduce any statements by Miss Lively or her team on this matter would serve only to confuse the jury and waste judicial resources. And then the final motion in limine, number 8, preclude the testimony of non-party Shusty Flo. The court should preclude defendants from calling non-party Shusty Flo as a witness at trial pursuant to rules 401, 402, 403, 404, and 701. Ms. Flo is a self-described entertainment reporter and multimedia producer who operates a YouTube channel on which she shares some of her good and bad experiences working in Hollywood and interviewing celebrities. Her sole connection to this litigation is that on August 10th, 2024, one day after the film's premiere, and as defendant's harmful narrative concerning Miss Lively was gaining traction, Ms. Flo posted to her YouTube channel a 2016 press junket interview she conducted with Miss Lively. In that 8-year-old video entitled The Blake Lively Interview That Made Me Want to Quit My Job, Miss Flo began remarking to Miss Lively, first of all, congrats on your little bump, referring to Miss Lively's pregnant belly. Taken aback. Why would you be taken aback by someone saying congratulations when you're like 7 or 8 months pregnant? I mean, it's just fucking ridiculous. Taken aback, can't even see it, by the comment on her body. Oh my god, did Shusty Flo sexually harass you? Miss Lively responded, congrats on your little bump. Miss Flo has since publicly characterized the interview as a traumatizing experience and maintains that her decision to post the 8-year-old video in 2024 was unrelated to Mr. Baldoni or It Ends With Us. Right, it was not just that comment about the bump, for God's sake. It was the fact that they flat out ignored Shusty the whole way through. Just acted like a pair of idiots. Her and Posey, was it Parker? Posey Parker, isn't it? I can't remember her name. She's irrelevant. But you know, they were just being so rude and ignoring Shusty. They were not answering her questions. And when she did ask a question about clothes, Blake Lively went on a virtue signaling rant, basically, about, oh, you never ask the men things about questions, which is not true. I hate how sensitive some people are. I mean, they mock Justin Baldoni and say, oh, you have a thin skin because, you know, because of Nicepool and you got upset about it. How is this not the textbook definition of a thin skin? I'm getting annoyed now again. Since August 2024, Miss Flo has posted hundreds of videos on her YouTube channel critical of Miss Lively and sold merchandise through her Etsy shop containing disparaging messages about Miss Lively and expressing support for defendants. Defendants include Miss Flo on their witness list, proffering that she will testify about her interview with Miss Lively and Miss Flo's republication of that interview in 2024. And yet she's got Claire Ayub on her witness list. This testimony should be excluded on multiple independent grounds. 1. Any testimony Miss Flo could properly offer lacks any tendency to make a material fact more or less probable and is inconsequential to Miss Lively's claims, rendering it inadmissible under Rules 401 and 402. 2. Even if relevant, Miss Flo's testimony constitutes inadmissible character evidence under Rule 404A1. 3. Any testimony Miss Flo offers regarding her views on the cause of the Little Bump video's virality in August 2024 would constitute improper lay opinion testimony under Rule 701. And 4. To the extent any portion of Miss Flo's testimony is otherwise admissible, it should nevertheless be excluded pursuant to Rule 404 because its minimal probative value is substantially outweighed by the dangers of unfair prejudice, confusion of the issues, and misleading the jury. First, Ms. Lively did not allege and does not have to show that Ms. Flaa's publication of the Little Bump video in 2024 was coordinated with defendants or resulted from any relationship with defendants or their agents. You dragged Shusty into this. She was referenced in the New York Times article. And then you had to concede that she was not part of the smear campaign and had no contact with anyone from Wayfarer's side. For the purposes of trial, Ms. Lively need only prove through precipitant fact witness and expert testimony that defendants amplified and bolstered the video to make it go viral. And that they did so, as a part of a retaliation for speaking out on sexual harassment. More specifically, that in the hours after Tag forwarded the Little Bump video to Jed Wallace on August 15th, 2024, 4 days after Flaa reposted it on YouTube, the comments on the video increased rapidly and at a disproportionate rate, as did the volume and popularity of comments that included bully-related terms, results consistent with a coordinated attempt to manipulate and boost content online. Against this backdrop, Ms. Flaa's proffered testimony is wholly irrelevant to Ms. Lively's claims, and the prejudicial impact is substantially outweighed by any probative value. Because Ms. Flaa can offer no insight into how or why the Little Bump video went viral on August 14th, the sole factor issue concerning the interview, her testimony should be excluded as irrelevant under Federal Rules of Evidence 401 and 402. Second, Ms. Flaa's testimony about her interview of Ms. Lively will inevitably echo her numerous public statements describing Ms. Lively as rude and exuding mean girl energy. Beyond being irrelevant to any claim at issue and barred under Rule 403, such testimony is inadmissible under Rule 404A, which provides that evidence of a person's character for purposes unrelated to truthfulness is not admissible to prove that, on a particular occasion, she acted in accordance with the character or trait. Third, to the extent Ms. Flaa intends to testify regarding how or why the Little Bump video went viral in August 2024, such testimony must be excluded under Federal Rules of Evidence 701. Rule 701 permits lay witness opinion testimony only when it is A, rationally based on the perception of the witness, B, helpful to a clear understanding of the witness testimony or the determination of a fact in issue, and C, not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Ms. Flaa's testimony would fail on even the first requirement, the familiar requirement of first-hand knowledge or observation. While Ms. Flaa may have personally observed the surge of viewership of her video, any testimony as to the cause of its virality, the only issue in dispute, would be pure speculation. I mean, to be fair, Ms. Flaa has personal knowledge of Blake Lively and what she's like. Ms. Flaa made no personal observations that would inform how the viewers of her video found the content or why they were compelled to click the link to view it. Ms. Flaa should not be permitted to guess as to how viewers came to engage in her content when, based on her own contemporaneous videos from August 2024, she admitted it was kind of crazy the video received over 10,000 comments in just 9 days, and assumed that the popularity was because a lot of people could kind of resonate with the situation. Because Ms. Flaa's belief for why the video went viral is based on her own conjecture and not any observable facts, her lay opinion testimony must be excluded. As Professor Coletta explains, inauthentic online activity spans a spectrum of tactics and actors that simulate organic user behavior, creating the illusion of popular support or dissent on social media. Identifying inauthentic behavior is not an exercise in common sense. Single account labeling can be challenging, therefore researchers rely on aggregate analysis to reliably reveal inauthentic influence on conversations. The testimony that Miss Flora can offer at best is anecdotal observations of single accounts, precisely the type of evidence that is unreliable for reaching opinions on whether online activity is authentic. Ms. Flora's opinion on whether viewers were organically engaging with her video is not grounded in any common knowledge or observations as required by Rule 701, but rather requires the specialized knowledge of an expert subject to this court's scrutiny on reliability. Fourth, if the court finds that some portion of Ms. Flora's testimony is relevant and otherwise admissible, the court should nonetheless exclude it under Rule 403. Ms. Flora's testimony carries at most negligible probative value, given that the question of whether Ms. Flora coordinated her post with defendants does not tend to prove or disprove any claim or defense. Whatever marginal relevance her testimony might conceivably have is substantially outweighed by the significant danger of undue prejudice to Miss Lively by Miss Flora coming into the court to paint her as a bully and a mean girl, in light of a 5-minute interview she conducted 7 years before Miss Lively ever met the defendants. But Lively was okay to subpoena Shusty Flo. Just to remind everyone, Lively obviously thought that she was relevant because she subpoenaed her. Her testimony also risks confusing and misleading the jury to the extent she is seen as having offered expert testimony regarding the virality of the video in 2024. For the foregoing reasons, plaintiff respectfully requests that the court grant the foregoing motions in limine and exclude the evidence described above from trial. Well, that was a lot. So the video didn't actually end up as long as I was expecting. I did think it was going to be a lot longer, but no. And that was with my ranting rambles as well in between. Thank you for bearing with that. Okay. So how can I summarize this? Evading accountability. I feel like someone is scared of being made to face their own bullshit. That's what I'm getting. Keep my statements out. Keep Nicepool out. Keep Vanzan out. I think Lively is nervous that all of this stuff is going to make her look bad. And it will. All right, guys. I'm going to do move on to Wayfarer's motions in limine, which are, should we say, a lot more measured and common sense.